So now it's my pleasure to introduce Jason Lien. He is going to talk about the December 1, 2015 amendments to the Federal Rules of Civil Procedure, which were to curtail disproportionate discovery. But have they really achieved that goal, particularly with respect to electronically stored information? Jason, the co-chair of the Litigation Group at Maslon in Minneapolis, is going to discuss how federal courts have implemented the 2015 rule changes to ESI discovery and what steps you should take in your next case to make ESI discovery proportional. And I do want to give you a fun fact about Jason. He told me at the break that he actually karaoke'd in the back of an Uber. So karaoke is a big theme here, I think, today. So Jason, come on up.
Good morning. If you are diehard NFL fans, or even if you're a casual football observer, you probably know that this weekend happens to be the NFL draft. And if you've ever had a chance to watch the NFL draft, it's a pretty interesting thing. Interesting stories develop. Day one is widely televised, millions and millions of viewers, and the top prospects are invited to a big city and paraded out one by one as they're selected by their teams. After that, the next few days will follow with the draft, but in much less fanfare. But it's often in those subsequent days that hidden talent is found. Tom Brady, pick number 199. Any Patriots fans in here? We all hate you. No, actually, we really like you. And an interesting thing about the NFL draft is the intrigue goes all the way to the last pick. The final pick of the NFL draft, many of you may know this, is bestowed the title Mr. Irrelevant. Now, you may think that that phrase would be a scarlet letter, but in NFL terms, it's a distinction of honor. They hold a parade for Mr. Irrelevant every year in Newport Beach, California. Every subsequent or previous Mr. Irrelevant is invited to attend this event. And so as I reflect on the events of the network this weekend, which happens to correlate in time with the NFL draft, I've drawn some interesting parallels. Day one of our presentation started with algorithms, emotion. We had a great panel discussion on crisis management. We then culminated in a story of betrayal and cover-up by the Alabama governor. Today, we've had some hidden gems, culminating in a Tom Brady-like performance by Emily on self-driving cars and a great GC panel discussion. Well, ladies and gentlemen, I am your Mr. Irrelevant. I am your final presentation. So, in that fashion, I would expect a parade, perhaps at the next network event. Would that be too much to ask, Felice?
No, I'll make it happen.
Okay, great. The 2015 amendments to the federal rules were the most significant in decades, and were aimed chiefly at discouraging and curbing excessive discovery that frankly got out of control. In 1962, 11.5% of all civil cases went to trial. Today, the percentage is about 1.7%. And many think that discovery and out-of-control discovery led to that. Now, the main change in the 2015 amendments was the restoration of the concept of proportionality as a tool that courts can use to curb out-of-control discovery. But have those changes really had an impact? I'm going to explore that question today, and I'm going to go through 4 topics. I'm going to talk about how the 2015 amendments came about, so you understand the intent. I'm going to talk about proportionality, 2 rules, specifically proportionality, and also a change to Rule 37 that was intended to curb sanctions for e-discovery, lost e-discovery. I'm also going to review the orders that have come out in the past 18 months by federal courts throughout the country, at least a few of them, so you can get a taste of whether or not federal courts are really giving these amended rules some teeth. And finally, I'm going to end by offering some tips that you can use to implement these changes strategically in your practice to curb back on excessive discovery costs. So how do we get here? Well, it's no secret that the main driver of the ESI problem that we have in today's litigation practice is due to volume. We have, every 60 seconds, there's over 168 million emails that are sent. You add to that all the other types of information that's distributed out there, and you can see why we have some problems when we get to producing and discovering. There's just a ton more information now these days. Now, it's not only the volume of information that's caused some problems, but also some other things that have contributed to the issue. There were some unintended consequences to the 2006 amendments, a specific change to Rule 37 that added some ambiguity, actually, and had the adverse effect of increasing the frequency of sanctions issued by the court for lost ESI. There's also an increased burden on companies that have to implement preservation plans, litigation holds, collection, review in litigation. So that has been also an issue. And then there's also been an increased and inconsistent use of e-discovery sanctions by courts. And this was caused by the ambiguity with Rule 37. There was a circuit split in the federal courts as to whether or not the negligent destruction of ESI would be available for sanctions. And the concept of proportionality, even though it existed in the federal rules, was all but forgotten. You probably grew up with the standard, I grew up with the standard of reasonably leads to the discovery of admissible evidence. If you trigger that standard, well, you're on a fishing expedition and you can get that discovery. So the 2015 amendments, how they came about is there was a 2010 advisory committee of the federal rules that sought about correcting this problem. And they created various subcommittees who then drafted the rules. They were presented to the Supreme Court in 2015. The most important rule, there's various amendments to the rules, but the biggest change was to proportionality and the restoration of proportionality. But Rule 1 was modified to set the tone. And this is the rule that is intended where the court is to secure the just, speedy, and inexpensive determination of every action and proceeding. That was amended to also include that the parties have that responsibility. And so you have the restoration of proportionality, and also there was a uniform standard that was created for Rule 37. Now, Chief Justice Roberts issued a year-end report in 2015 when these rules were implemented. And if you have a chance to read this, I implore you to do so, because he went out of his way to basically say that we are now going to change, there's going to be a mindset change here in discovery. And we want courts, federal courts, to use proportionality to curb discovery. And so now I'm going to review two of the changes, one to Rule 26 and one to Rule 37. So the big takeaway with Rule 26B1 is that the phrase reasonably calculated to lead to the discovery of admissible evidence has been deleted from the definition of the scope of discovery. So if you're objecting to discovery requests on those basis in federal courts, you are violating this rule because that is no longer a proper objection. The rule also added the explicit consideration of proportionality, that the discovery request must be proportional to the needs of the case, along with 6 factors that the court is to use when determining whether the request is proportional. So the new test for the scope of discovery is that the request must be relevant to a claim or defense and must be proportional to the needs of the case. If those 2 elements are not met, then the discovery will not be allowed. Rule 37E was changed to create a very clear test as to how and when sanctions would be available for the loss or destruction of ESI. Now there's a three-part test that a party must demonstrate in order to even be eligible for sanctions. The party must show that there was a duty to preserve ESI in anticipation of litigation, that the party lost or destroyed ESI as a result of failing to institute reasonable measures to preserve it, and finally, that the ESI cannot be obtained through alternative methods or means. Once those three tests are met, the court then is supposed to consider, number one, whether there's any prejudice to the other party as a result of the lost ESI. If there's no prejudice, the court can't issue sanctions. If there is prejudice, the court can only issue sanctions that are proportional to the harm that's caused. And only serious sanctions are possible if there's an intent to deprive. These are the types of sanctions. Default judgment is obviously the most serious sanction, but the adverse inference instruction is the most common sanction. Those types of serious sanctions now are only possible if there's an intent to deprive that's found. Here is a decision tree, this was published by the federal lawyer, that now shows how Rule 37E is supposed to be applied. And this is an algorithm, if you will, that demonstrates exactly how difficult now it is to convince a court, a federal court, that sanctions should be issued for the loss or destruction of ESI. It's difficult, and I think this chart shows that. So now I'm going to review some of the discovery orders that have come out in the past 18 months to give you a flavor of how federal courts are interpreting these amendments. First, with respect to Rule 26B, there's a case, Jalad Sciences versus Merck out of the Northern District of California. In that case, the plaintiff had sought discovery into this was a patent dispute, and the plaintiff sought discovery into several other compounds that Merck had that weren't really specifically relevant to the issues in the case. They could lead to some potentially discoverable information, but Merck objected that it was not proportional, and the court reviewed the proportionality factors and denied the request on that basis. And in doing so, the court went out of its way to talk about how the rules came about, that proportionality is really nothing new to the federal rules, but what now will change, hopefully, is mindset. And no longer is it enough to just show that it might be reasonably calculated to lead to the discovery of admissible evidence. You've also got to show that your request is proportional to the needs of the case. Another case that had a similar result was the Wilmington Trust case out of the Southern District of Ohio. That request dealt with a party that sought additional ESI requests that would have resulted in the production of about 1 million pages of ESI. And the defendant objected that it just simply wasn't proportional given the few amount of possible relevant documents or pages that would be produced through that exercise. And again, the court used proportionality to deny that request. This is a recent decision, the Fisher decision order out of the Southern District of New York by Magistrate Judge Peck. And this is a very interesting order because Judge Peck went out of his way to, not only did he highlight all the different violations that the counsel that objected to discovery committed to the amended rules, chiefly among those failing to be specific in objecting to document requests and relying on general objections, but also relying on reasonably calculated to lead to the discovery of admissible evidence. Judge Peck ordered the attorney to resubmit discovery responses complying with the rules, and then basically said that, and by the way, I'm doing a wake-up call to the bar of this district, that any lawyer that appears before me, if you do improper objections, you will have deemed to have waived your objections. So if you practice in the Southern District of New York, make sure you read this opinion. Now, Rule 37 has been applied as it is intended, I believe. I'm seeing that there are many cases where sanctions are just not being awarded now, or as much frequency. The new Vasive case is an interesting case. It's out of the Southern District of California. This highlights the power of the amended rule here with respect to 37E. Prior to the amendment, the court granted sanctions for the party's negligent failure to preserve text messages. Now, smartly, after the lawyer received that adverse ruling, the rule was amended, and he filed a motion, or he or she filed a motion for reconsideration under the new rule. The court considered that, and on reconsideration, applying the amended rule, said that sanctions are not available because all you had here was a negligent destruction of ESI, and there's no prejudice. Similarly, the Living Color Enterprise decision out of the Southern District of Florida, that also showed how difficult it is to get sanctions. Even though the party met the 3 initial steps to be eligible for a finding of sanctions under the new rule, the court declined to issue any because there was no prejudice and there was no intent to deprive. So have the changes had an impact? It's still a little too early. We're 18 months in. It's still a little early to tell how they'll be embraced in the long term. But what I'm seeing is, particularly as of late this year, courts are taking notice of the changes and following the intent of the drafters to scale back discovery requests, in particular e-discovery, and also scale back the use of sanctions. A large number of cases have applied proportionality to rein in discovery and also denied discovery sanctions altogether, or have made them proportional to the prejudice that may have been caused. There was a study by a company called Kroll on Track. It's a e-discovery vendor, and they reviewed all the ESI opinions that had come out in 2016, and they observed statistically a similar trend. They found that 56% of all orders on ESI dealt with the issue in 2016 of proportionality. The year prior to that, the number of cases that actually cited proportionality were half that percentage. So there is definitely a trend where courts are embracing proportionality. So my challenge to you and my parting words are that, many of us have heard about these amendments, but if you practice regularly in federal courts, I think it's really important that you study them and you strategically implement them. I've only highlighted a couple of the amendments, but there's other amendments as well that you can use to put reasonable measures in place and restraints on discovery. Specifically, here's a couple of them that you can implement. Is early on in the case at the Rule 26F conference, there are amendments to that section of the rule, and it allows you to be very aggressive in setting the boundaries of discovery with the judge. You can actually serve document requests in advance of the Rule 26 request conference to set some of the boundaries for discovery in the case and what issues are really in dispute. You can include e-discovery provisions protocol now in the scheduling order. That's now specifically permitted and contemplated in the federal rules. And importantly, if you're objecting to discovery requests, be very specific. Remember proportionality and know your costs and your burdens that the request is going to impose on your company. These are some of the factors that the court is going to consider in determining whether the request is proportional. And finally, implement a reasonable ESI preservation plan. You don't need to go overboard. It's got to be reasonable to avoid sanctions altogether. One of the 3 elements that has to exist is that there was no reasonable steps or reasonable preservation plan in place. If you have a preservation plan in place and you can demonstrate that you followed it, there's a good chance that you can even eliminate the possibility of sanctions if some ESI was destroyed or inadvertently lost. Thank you very much for your time.